Islamic inheritance law, and I will explain to you how you have. So a very popular question that people like to ask is, how will my estate or my wealth be distributed after I pass on? Now, before we answer this question, it's important to know what forms your estate after you pass on. So for instance, if there's a family, husband, wife, they have 2 children, and the husband passes on, and the house is held in joint tenancy, then the house will be fully owned by the wife. It will not be subject to division. Similarly, if he had nominated his CPF and insurance, that the monies there will also not be subject to division. So what would be left for division would be anything in his sole bank account, or any assets he have, for instance watches or gold, for instance, that would be liable for distribution to his beneficiaries. Now, the critical thing that we must understand is that many people want to do it their own way, not in line with Islamic inheritance law. Now, the Administration of Muslim Law Act clearly states, Section 112, that if a Muslim domiciled in Singapore dies intestate meaning without a will, then it will be subject, his estate will be distributed according to Islamic inheritance law, according to Muslim law, right? According to Muslim law, which is Fara'id, and Fara'id means inheritance law. As simple as that. So we need to understand then, how can we make use of the various instruments in order to do our estate planning. So there are a number of instruments that one can use. Wasiat is just one of them. Many people call me and they say, we want to do a wasiat. But when I ask them what they want to do, what they want to do doesn't fall within the ambit of a wasiat. Simply put, in a wasiat, you can choose how you want to distribute 1/3 of your estate, because a Muslim is given leeway. He can give away 1/3 of his estate to a non-beneficiary. He can sedekah to the masjid, he can give to his maybe his adopted child, he can give to his nephew or niece, or nephews and nieces, or anyone for that matter, even a friend, right? But apart from that, the wasiat has to be in accordance with Islamic inheritance law. The wasiat cannot state, I'm giving my 2/3 to my nephew, and just remaining 1/3 I distribute amongst my the rest of my family members. The family members can challenge this wasiat, and the wasiat can be set aside. So this is very important for us to note. Another thing that you can do in your wasiat is to choose the administrator. Administrator in Malay would mean pentadbir, the person who manages your estate. That means the person who will go to court and say that, I am the intended, I'm the administrator of the estate according to the will, give me that grant of letters of administration, and then I will go to the respective bodies and be able to withdraw the money or sell the house, for instance. So we must understand what is the purpose of the instrument that we are using. Similarly, for a hibah. Hibah, you have 2 types. You have just the hibah, which is a gift, a deed of gift. You can give it when you are alive. But many people do something called hibah rukbah, which is conditional, right? If I predecease you, the gift is yours. But if you predecease me, the gift comes back to me. Now, hibah rukbah is slightly problematic in the sense that not all the scholars agree as to whether it is valid under Islamic law. But other than that, even the courts will actually ask for the beneficiary's consent, that they agree with what is stated in the hibah rukbah. So this is a bit complex, and many people don't know this. So let's say, for instance, there is someone passes on and they give a hibah rukbah. Let's say the hibah rukbah forms about 40% of the estate, 40%. That means more than the 1/3 allowed by faraid. So 40% goes to person A and he dies. So can it be, can this hiba rukba be valid? Well, can the family members challenge if they are not happy? The answer, simple answer is the family members can challenge, and if the hiba rukba is not consented to by the family members, the beneficiaries, his faraid beneficiaries, then the hiba rukba will not be followed. The court will not pay any attention to the hiba rukba. Same thing for hiba rukba also works for nuzuriya. Nuzuriya is an instrument that that would state that 3 days before, something like 3 days before a person passes on, a certain amount of the wealth will go to this person. Now this was very popularly used by Yemeni traders before World War II and sometime after that. So even its validity, according to Muiz, is valid, but not all scholars agree that Nuzuriya is something that is 100% no controversy. So this is something that we also have to discuss. So before we use these instruments, whether it's a hiba, whether it's a hiba rukba, whether it's a nuzriya or wasiat, we need to know the purpose of these documents, purpose of these instruments. What am I trying to achieve? So before you decide that I want to do a wasiat, your first step is you have to know what goes into the estate. You need to know that first. And the second thing you need to know, how do you plan to do it, to divide it in a way other than that of faraid? So let's say 2 boys, 2 girls. Instead of giving 2, 2, 1, 1, you want to give it equally amongst everyone. Then you have to call your children together, provided they are adults, and get them to agree. If they agree, you can do a document called a deed of family arrangement, where all of them sign and say we agree with father's or mother's proposal to divide everything equally. Then it's fine. Okay, there is provision if the beneficiaries agree, because the principle in Islam is not to oppress any beneficiary. Right? Islam is against all forms of oppression. So if the beneficiaries agree, it's fine. So it's very similar to the previous example I gave on hiba rukba. If the let's say there is a hiba rukba, and the beneficiary said, doesn't matter, we will respect our father's wish, or we will respect our mother's wish, and we just consent to whatever he agrees, then it's fine. Or let's say even if the wasiat is defective, the wasiat states, I give 50% to one child, and the other 50% to be divided amongst the 3. So it's clearly not in accordance to Islamic inheritance law. But if the children say, look, I know it's not in accordance, but this was dad's wishes, I will respect it, we can do the courts will ask for an affidavit of consent for the beneficiaries to consent, and then it will be accepted. So we must understand how Islamic inheritance law functions in Singapore. The Sharia court's role is to provide the sijil warisan, or the certificate of inheritance. Then you apply for the grant at the family court, not at the Sharia court. Then if there is a dispute between the family, let's say on some issue, the family court will decide it. The family court and the high court will decide this issue, not the Sharia court. And they will apply Muslim law and the law of Singapore in deciding, in determining the outcome. So it's very, very important for us to understand that. So number one, there is you have to understand what goes into the estate. Number two, you need to understand, you need to know how you want to divide it. You need to know whether your beneficiaries will consent, and so on and so forth. Now, there is obviously a final category that I want to share, which is that of a trust document. You can create a trust. Right? Let's say you put everything under a trust to be divided in a certain manner. Now, will this be held to be contravening amla? There is no case law to suggest this as of now. So one can still use that as an option, but whether it can be challenged, obviously anything can be challenged. But it remains to be seen how the courts will look at a trust in light of section 112 of AMLA. So essentially this is what I wanted to share today. It is very important for you to discuss, understand the purpose, understand what goes into the estate, understand how you want to divide it, and understand your family members, are they going to agree or not. The very simple singular purpose of putting everything down in paper is for clarity. You just want clarity. If you trust that your children are going to follow everything you say very clearly and nobody is going to change their word, then there may be no need for to write down anything. But it's always best to do so, because different people may have different views. They may perceive something differently as compared to you. So this is very important. Write it down, get it done with a law firm, get it done with a lawyer, understand the law very clearly, and then proceed to do what you want to do. Thank you. Assalamualaikum warahmatullahi.